Imagine a police officer makes a split-second decision, not because he has to, but because he puts himself into a dangerous position. And because of that decision, it ends up with someone maybe that you love being shot. Now imagine the courts look at the situation and say that the use of force was still reasonable, even after the Supreme Court issued a 9-0 decision in your favor, saying that the legal standard that the court has used was incorrect. Because that's exactly what is currently happening in this case, which is once again heading back to the Supreme Court for consideration just months after that first 9-0 ruling. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. They've added things like civil liability coverage, red flag law coverage, 4 guaranteed attorneys for your self-defense case, and now they also added in the hero clause. So if you're interested, if you want to check them out, you can do so using the links down below. And if you decide to sign up, you can use the code ARMEDSCHOLAR to save $25 off of your sign-up fee. Now, as I mentioned in the intro, we have a critical case which is once again heading up to the Supreme Court for consideration, even after they originally ruled 9-0 in favor of the family just last year. This case is called Barnes versus Felix, and it centers around the 4th Amendment and when police can use deadly force. So in this case, an officer pulled over an individual, Ashton Barnes, for what began as a minor toll violation. I believe it also involved a rental car. Now the officer, upon that stop, ordered that Barnes exit the vehicle, and Barnes opened the door and acted as if he was going to comply, but then he attempted to drive away. Now, responding in a split second, the officer decided to jump onto the ledge of the car where the door was open, just kind of right there on the door seal, and he was, hanging onto the car as it was driving away. He then decided to pull his weapon and fire 2 shots into the vehicle and then fatally struck Ashton Barnes. Now, in response to this incident, his mother then filed a Section 1983 civil rights lawsuit, arguing that the shooting constituted excessive force under the 4th Amendment. Now, on review, the lower courts originally ruled in favor of the officer using something called the moment of threat rule. Now, under that rule, courts focus only on the exact moment when deadly force was used. Everything leading up to the moment is actually ignored. So using that narrow framework, both the District Court and the 5th Circuit ruled in favor of the officer. That then led this case to go to the Supreme Court for the first time, and the Supreme Court on review issued a 9-0 unanimous ruling rejecting the moment of threat doctrine. The Supreme Court held that excessive force cases must be evaluated based on the totality of the circumstances. Essentially, the courts must look at everything leading up to the use of force, not just the final split seconds. So this principle comes from long-standing Supreme Court precedent requiring courts to evaluate the full factual context surrounding police encounters. So after that 9-0 ruling, the Supreme Court sent this case back down to the 5th Circuit with very clear instructions. Reevaluate the case using the totality of the circumstances framework and issue a new ruling. But after that case returned to the 5th Circuit, then something very unusual happened. The panel in the 5th Circuit then decided to not hold any oral arguments. They did not request any additional briefs from the parties based on what the Supreme Court said, and they did not send the case back down even to the District Court for a new trial record or anything like that. Instead, the 3-judge panel issued a new decision, and they ruled in favor of the officer, and they just did that on their own. But this time, the court used a different theory. The court reasoned that because Barnes attempted to flee in a vehicle, he created a risk of flight that could endanger others on the roadway. Therefore, they found that the officer's use of deadly force was reasonable. According to the new Supreme Court petition, this effectively creates a rule allowing deadly force anytime a suspect is fleeing in a vehicle. And they say that the rationale there is that the officers could always say any risk of flight or any actual flight in a vehicle poses a potential danger. And that's the key issue now being presented to the Supreme Court. Just months after the Supreme Court issued a unanimous decision in this case, the plaintiffs are back in the Supreme Court asking the court to intervene once again. The new petition argues that the 5th Circuit's risk of flight doctrine conflicts directly with Supreme Court precedent. In particular, they point to the Tennessee versus Garner case, which held that deadly force cannot be used simply because a suspect is fleeing. Instead, deadly force is only justified if the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical harm. But according to this petition, the Fifth Circuit's new ruling in this case effectively lowers that standard beyond what it was already. Instead of requiring a serious threat, the court's reasoning suggests that the just simple risk of escape alone could justify deadly force. And the petition argues that that fundamentally changes what the Supreme Court has said in its precedent. And, that is directly conflicting what the Supreme Court has said in prior cases and also what they told the court here to do based on that 9-0 ruling. There's also some new procedural developments that could also affect how quickly the Supreme Court moves on this issue. The defendants have now filed a waiver of response to the cert petition. So essentially what that means is that the defendants here are telling the Supreme Court that they do not intend to file a brief opposing Supreme Court review, essentially unless the Supreme Court actually orders them to file that response. Now, this is actually fairly common, but it also means that the Supreme Court can move on the case and move it to conference on their own if they want, but also it indicates that the government here just simply does not believe the Supreme Court is going to grant review to this case, and they're not going to respond to this until the court tells them to. And now, after that waiver, we have an interesting update. The Supreme Court has distributed this case for conference on April 24th, and so that means that the Supreme Court is now setting a date to potentially look at this case at conference. And importantly, they did this without first requesting a response from the government. So as of right now, a response has not been filed, it has not been requested by the Supreme Court, and simply, the petition is just sitting there, and right now there has been a date set for conference. So what could happen now? Well, just because this was scheduled for conference right now without an order for a response does not mean one will not be requested or ordered by the Supreme Court. Anytime leading up to that conference or even after that Supreme Court conference, the court there could demand a response from the defendants. If this makes it to the conference day without an order for a response, one thing we will be watching for is essentially the following order list. That could indicate a quick denial of the case, or that the court would simply just move and issue an order for a response in the order list after that conference. I would anticipate a response will be ordered by the Supreme Court before April 24th, and the conference date, will just be simply removed and pushed to a different date. But that is something that we're going to have to watch for closely, because now that this case is back in front of the Supreme Court after the Fifth Circuit really did not look at what the Supreme Court said and they just used a different theory, this is an interesting case, and we want to see, what the Supreme Court wants to do with this challenge. So where does this currently leave us with this critical case? Well, of course, like I said, you have that 9-0 Supreme Court decision already in this case that was issued by the Supreme Court in favor of the family. A lower court then reached the same outcome, just using a different legal theory, talking about the risk of flight. And a new petition has been filed to the Supreme Court asking for them to intervene once again. And now we have a waiver from the government saying that they're not going to respond to this. The Supreme Court has set this for conference, but as of right now, no actual response has been ordered by the court. So we're going to be watching to see if that actually comes. So now this case is in a very critical phase. We're going to be watching to see what happens before that scheduled conference, because that could really just tell us what the Supreme Court intends to do with this case. So that's the latest development right now in this critical Barnes versus Felix case, dealing with the Fourth Amendment and, police officer excessive force issues. As we get more information, as it develops more, I will let you guys know. If you have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.